Good morning. It's time for us to start our meeting. And we've also formed a quorum. So let's start. First of all, I'd like to welcome all of you to the meeting. Thank you for attending. According to the agenda, first of all, we have to handle Mr. Paul TSE letter dated the 23rd of September, which says that he would like to join this Bill's Committee on Property Management Services Bill. The letter has already been distributed to you. Members, any comment on this request from Mr. Paul TSE? If there are no comments, we approve his application. And thank you very much, Mr. TSE, for helping us. Item 2 on the agenda. We would like to invite the government representatives to enter the conference room first. On the 23rd of July, we met with the deputations and the administration. At that meeting, the deputations and the administration made a number of comments and raised a number of concerns on Property Management Services Bill. Earlier, the administration has already submitted its responses to the Bills Committee, and those papers have already been distributed to you. Welcome, representatives of the government. We have a number of papers today. First of all, CB bracket 2. (22/1415) bracket 01, bracket 02, and bracket 03. Concerning paper 22 bracket 01, the administration has addressed members' concerns and has provided some information, including information on those buildings not regulated by the licensing regime, and the estimated total number of these buildings, as well as what's mentioned in Schedule 1 in relation to the general management services of buildings. And a general definition is provided. As regards paper 22 bracket 02 and bracket 03, they're actually the administration's response to views and concerns expressed by the deputations in respect of the specific clauses of the bill. I mentioned 2 response papers. Of course, bracket 02 is about policy areas, and then bracket 03, it's about a tabulated response to views and concerns raised by the deputations. If there are no other comments, I'd like to invite the government representatives to briefly take us through the papers. And then I'll see what follow-up questions members have and whether or not there are other concerns. Mr. Chan? Thank you, Mr. Chairman. Good morning, members. Mr. Chairman, on the 23rd of July, at the meeting, members asked the administration to provide supplementary information. First of all, those buildings not regulated by the licensing regime and the total number of such buildings. And then the definition on the general definition on property management. The information has already been submitted to you, mainly in paper 22 bracket 01. up to September, that is last year, with 40,000 private buildings in Hong Kong. Among them, around 8,500 are managed by OCs. And then 5,000 odd are not managed in any form. That is, they are without any management services. Last time, members asked why we've been adopting a very broad definition in relation to general management services. We also explain in the paper that Schedule 1 of the bill mainly observes the qualifications framework in relation to general management services. There are 7 categories. General management services relating to a property, management of the environment, management of facilities, finance, legal issues, and so forth. Members need not worry. After the enactment of the bill, by way of subsidiary legislation, will categorize the management services. And after the regulatory regime is set up, we'll go into the specific contents. Take, for example, codes of conduct can be promulgated. As the chairman mentioned, on the 23rd of July, the deputations raised concerns about policy areas and specific concerns about the various provisions. Our responses are set out in bracket 02 and bracket 03. And then the Law Society also commented on our views. And the government's response is in bracket 04. Members, any follow-up comments or questions? Mr. Wong Kwok Hing. 5 minutes per member, including questions and answers. Thank you, Mr. Chairman. I'm very pleased to see these papers in response to members' questions and concerns raised last time. Answers have been provided in these papers. I'd like to further follow up on some issues. That is the licensing regime for members of the industry. Mr. Chairman, can you or the administration arrange another public consultation exercise for members of the industry? Why am I suggesting this? It's because since this bill came to the LegCo, we heard the views of some stakeholders. As regards individuals and organizations of the industry, relatively fewer have come to express their views. After the last meeting, some of them told me that they're worried that in future, after the enactment of the licensing regime, their employment and prospect might be affected. In particular, for the proposed 3 years of continuous professional education or training in order to obtain professional qualifications, they're worried that that time frame would not be sufficient. I actually received the views from an organization in the trade, in the industry. At the moment, the working hours are long for the industry. Now, this is well known. If the members are to complete these training courses within 3 years in order to obtain more advanced qualifications, they're worried that time might be too pressing for them. So they're of the view that 4 years might be better. But of course, this is only an example. So can you, at an opportune time, arrange another public hearing to allow individuals and organizations from the industry to come and express their views, and we're very concerned. Mr. Chan, any response? Thank you, Mr. Chairman. I'd like to thank Mr. Wong for his questions. The interest of the industry is our concern. One of our guiding principles is that we do not hope that this legislative exercise and the licensing regime would not lead to loss of manpower. We just want to enhance their professional standards. That's our main concern. And before this exercise, we carried out a great deal of consultation to consult members of the profession. In the consultative body, we have representatives from the industry. Some of them have very high educational qualifications as well as frontline experience. Some have management experience, rich management experience, but lower educational qualifications. The concerns of individual members of the profession have been addressed by us. As regards the transitional period of 3 years, we would like to strike a balance. We also received comments from the public as well as from councillors that we would like to have a comprehensive licensing regime. The worries that individual members and organizations of the profession would like to have a longer transitional period. After deliberation, we came to the view that 3 years would be more appropriate. Continuous training is very important. In the consultative group, we consulted the tertiary institutions that launch such training courses, and we do have expert representatives. After the licensing regime is established, tertiary institutions, academic institutions, and the like will provide training programs. It's good for us to listen to more views. I'll say, after today's discussion, after policies are clarified, whether or not we should further consider inviting deputations and individuals to come. The last public hearing was on the 23rd of July, not too long ago. I agree that we should listen to more views. Perhaps we should follow up on this later. Next, Mr. Ip Kok Him. Thank you, Mr. Chairman.
Haven't heard from Wong Kok Hing. I do want to express a different view. I think property management is not actually a new issue. There have been much discussions on it before, and then the government was urged to submit a relevant bill. Just then, the issue raised by Mr. Wong then, indeed, even before this committee was formed, had been actually debated on. Some thought that we should go fast on this issue, some that we should adopt a slower pace in tackling the issue. Mr. Wong just then asked whether we could hold more public consultations, listen more views. Of course, we need to listen to more views, but for our Bills Committee, we do need to do our scrutiny. Members can actually debate on the period involved, whether it's 3 years or 4 years. That's our responsibility. If there is a need, I think based on my past experience, if there is a need, then our Bills Committee can still listen to more views. But let's not reconvene a session of public consultation, because everyone will have different views anyway. Personally, I think that the property management companies must be licensed as soon as possible in order to put the industry on the right track. Otherwise, now that the standards of the companies vary so much, some, of course, are very good companies, but there are others which are really disappointing to people, and that really actually affect the overall quality of buildings, or even reduce the quality of buildings. So we need to think about how we can enhance the standards. As mentioned in the bill, there are various ways we can do to enhance the quality. Actually making sure that companies live up to prescribed responsibilities and so forth. So I'm very interested in detail, but I do think that we need to discuss the proposals one by one. In the paper, in section 3 of the paper submitted to us, I want to ask the administration the figure that you gave us. That is, you said there are about 40,000 buildings in Hong Kong, of which 8,500 have owners, corporations, and other organizations set up by owners, and there are 5,900 blocks. About 10% of the overall were not under any sort of management. So what about the rest? Can you give us a clearer idea? Are there buildings that are actually run by the owners themselves or self-run? Thank you, Mr. Yip, for your questions. In Hong Kong so far, there are about 40,000 private buildings, of which most of them are run by property management companies. More than 8,000 buildings are run by their owners' corporations. So there's quite a number of them. Some owners' corporations feel that they can manage or run their own buildings, and so they hire staff directly. So these are tend to be single block buildings with a limited number of flats. And the management only involves a certain area, that there won't be any clubs to manage, nor car parks. So we're talking about mainly single block buildings, in which the owners feel that they can just hire their own security guards and cleaners to look after the buildings. Our information shows that quite a number of these buildings run by owners' corporations are of quite good quality. Some actually are in quite expensive locations. Another type, that is about 5,900 buildings, they are buildings that are not run by any residents, nor owners' corporations, nor management companies. So these buildings actually are the target buildings for us, because these buildings are not run by anyone, neither management companies nor owners' organizations. So the quality is dubious. Therefore, actually recently we've launched a number of measures to help this type of buildings. So follow-up question. So in other words, are you saying that 64% of the buildings are run by management companies, right? Yes. Next one is Wu Chi-wai, Vice Chairman. Thank you, Chairman. 2 questions last time. When we discussed the bill, we were all very concerned that there would be quite a large number of subsidiary legislations to be submitted in the future. For example, regarding the formation of the monitoring committee and the property management petitioners, what would be the code of practice for them and so forth. These details would need to be discussed more thoroughly in the future when we are looking at the subsidiary legislations. At the public hearings, we heard concerns that once the bill is approved, if we don't know what about the idea about the overall regulatory framework, then there may be concerns, outstanding concerns. And also, for some subsidiary legislations, maybe part of the content of this legislation should be incorporated into the main bill or amendment. Otherwise, even though the bill is passed, there still may be a gap. So I want to know, when are you going to submit to us the information related to subsidiary legislations? And secondly, for the entire trade, we all know that we don't know indeed how many people there are actually in the entire industry. Do you think that they are able to cope with the new legal requirements? And also, based on the paper submitted, after 1990s, there were only degrees offered to people interested in property management. So based on that, do you have a data, or have you discussed with the relevant institutes that is in the market? What is the distribution of labor like in the market? We'd like to have a better grasp of the employment situation now. When we looked at the Chinese proprietary medicine practitioners ordinance, we had to talk about not just the transitional arrangements. We also need to consider the number of people who are actually qualified for the trade. And we did look at ways to allow these people with the basic qualifications to be eligible for the profession or to take part in the provision of Chinese medicine practice. Of course, through various institutes, you had obtain information from them, but I'm sure you will have a way to find out more or extract information about the situation of the trade. We don't want to see that after the bill is passed, there is indeed an acute labor shortage, which means that the fees for property management could rise in the future after the bill is passed. Also, have you assessed, once the bill is passed, so will there be companies that will be merged to actually cope with the demand for services when the number of practitioners is limited? Have you actually done any assessment on the future market situation once the bill is passed? Thank you. Mr. Chen. Thank you, Mr. Wu, for your 3 questions. Firstly, on subsidiary legislations and the details related to them, I understand members' concern. In the drafting stage, and when mapping up the licensing regime, in many meetings we did mention the specific requirements we have in mind. We did have thorough discussions, but now because our focus is on the bill, the main bill, therefore we tend to focus on the general principles and framework. But the details are there. So may I suggest that when you do the clause by clause scrutiny of the bill, when there's a need to look at the actual details, I will tell you about those details. Instead of disclosing the details now at this early stage, in order not to confuse you, I think we can brief you on the details when we actually are at the stage of looking at the individual clauses in the bill. And secondly, about the number of petitioners, we are very concerned about that. Mr. Wu put it right. In the absence of a licensing system, we don't have an accurate data, but through various channels and contacts with the institutes, we do have some basic information. For example, for the Category 1, Category 2, or Tier 1, Tier 2 grades, according to the Institute of Housing in Hong Kong, we think that those who there are about 4,500 who can qualify for Tier 1 and 7,000 who can qualify for Tier 2 petitioners. As for the exact requirements, whether it's Tier 1 or Tier 2, actually these people should comply with our future requirements, even though there may be some gaps. Just as Mr. Wu said, there is only till 1990s that degrees were offered for the petitioners. But there are petitioners who got their qualifications overseas rather than Hong Kong. Okay, maybe you can supplement later. I think you can supplement later when there's time, but let's ask the next one, Mr. Hon Paul, to speak. Sorry, excuse me for being late. I think we're looking at the government's responses, right, to the concerns. So yeah, you have 5 minutes. Yes, firstly, I think the administration It's very clear. In page 6 of your response, Mr. Manchiwa said that for buildings run by owners' corporations, these buildings would not be subject to the regulatory regime. But as you said, during the public consultation period, people are saying that the buildings that were managed by IO, they should not be subject to the licensing, and also these buildings run by IO actually tend to be single block buildings, and there are not that many flats there. But in where I live, there are 13,000 residents and more than 200 flats there. So sometimes I agree for single block or 2 block buildings, it's fine to exempt them from management. But for buildings with more than 2,000 flats, or extreme case like the entire Taikoo Shing or Horizon Plaza with 10,000 flats, would you, I think there's a big loophole in the bill, would you exempt these large estates from property management? I think we can discuss, whether there's need for management or regulation on estates with just 200 or a few hundred flats. That's fine. But for estates with more than 1,000 or thousands of flats, they need to be subject to proper or regulatory regime, because otherwise, there could be unscrupulous individuals who set up owners corporations to run these limited number of flats. If you let these unscrupulous individuals to run single block buildings, then that would actually be a deviation from your original idea. You need to think of a way to impose control. For example, buildings with 100 or 200 flats. Otherwise, you need to think of an amendment. You do really need to think of an amendment to impose control on the number of flats that actually should make it necessary for the owners to impose control. Otherwise, you create a loophole, allowing unscrupulous individuals to buy flats or to run flats the way they like. So you need to respond to that indeed, to plug this loophole. Thank you, Mr. Chen, for your question. All along we are aware of what you're saying, and we've actually tried to do the work properly. We feel that based on our information of the 8,000 odd buildings run by owners corporations, we found that most of them are old-style single-block simple buildings. As Mr. Chen said, for large estates with 2,000, 3,000 flats, I think they don't belong to that kind of category of buildings. For Taikoo Shing, Taikoo Shing has its own owners incorporations, and they have DMC. They have DMC managers, not owners corporations, and they also have their own management companies. For large residential estates which do not have their own profit management companies, I think that's something very rare in Hong Kong.
As regards Mr. Chan's worry, I don't think the chance is high for that scenario to happen. At the end of the day, it's the responsibility of the owners to oversee the management of their buildings. They shouldn't allow unscrupulous elements to conduct illegal activities. Mr. Chan asked for a figure. During the public consultation exercise, we received a very strong view. That is, for OC-managed buildings, they shouldn't be covered by the bill, because basically at the moment, the owners, corporations proactively manage the buildings on behalf of other buildings. They may be dealt a heavy blow on these 8,000 odd OC-managed buildings, and the reaction may be strong. Rather, we should support these OC-managed buildings instead of including them in this licensing regime. Perhaps the administration should consider this worry. The worry is that after legislation, you have to plug loopholes such that unscrupulous elements would not make use of the licensing regime to evade their responsibilities. You mentioned policies. In future, the provisions in the bill may involve such concerns. Perhaps later we should have another more focused discussion on this. Today, members have raised policy concerns. For example, those concerns about exemption. Other concerns may be raised in a moment. I'd like to briefly add that concerning Mr. Wong Kwok Hing's concern, deputation still wrote in after the 23rd of July to provide supplementary information or new information and new views. So you can invite the deputations and individuals to submit their views to this Bills Committee in writing, such that we can follow up on those comments, and we can listen more to the views of deputations and individuals. Next, Mr. Frankie Yik. Thank you, Mr. Chairman. I think the bill itself should have public support, but members are worried about certain details. Members of the profession, particularly those with no educational qualifications but experience, you allow them 3 years to study for a qualification. Well, if they had studied hard for educational qualifications, they wouldn't have ended up like this. So you should give exemption to affected persons. Take, for example, the electricians. So long as they're up to standard, the government would give them a license. If I remember correctly, well, Mr. Chen Kim-po can rectify me. When we have legislative amendments for the members of the insurance industry, exemption was granted. Why can't we have exemption in this exercise? You said that you would not like to affect members of the profession, so please consider that, because we do have precedents. Mr. Chan Kim-po was correct. You said that there are no examples in reality, and OC managed buildings are managing their own buildings. So you're saying that you only regulate the good guys, you only regulate the bad guys, but you have to reconsider this. For 1761(03), in paragraph 13, you mention disciplinary details. The authority will not investigate into complaints based on erroneous understanding. And for frivolous complaints, the authority may not investigate. Well, first of all, if there is a complaint, the authority must handle that. Otherwise, people may complain. In fact, there had been unreasonable and frivolous complaints. In fact, we know that almost all government departments had looked into complaints in a particular housing estate. Now, in future, when the authority receives such complaints, will it listen to the owners' corporation's views or the owners' committee's views before conducting an investigation? There are 2 questions. Oh, 3. Exemption, Mr. Chen Kim-po's suggestion, and future investigations. The first question is about the experienced members of the profession. During the consultation exercise, we repeatedly considered the concern. In our opinion, for those experienced members of the profession who do not provide the necessary educational qualifications, will provide them with a 3-year transitional period such that they can take up training courses to obtain the required qualifications. Of course, some members of the profession may think that they are experienced enough and do not need these continuing education. Well, we'll take care of different scenarios. In future, the authority can require these members to undergo continuing education. Besides, these members of the profession can submit papers to indicate their experience, or they can provide evidence of their achievements in managing housing estates in the past. Well, if some members don't want to write essays, the authority can consider interviewing these members to recognize their qualifications and experience. So members need not worry. When we work on the details, we'll consider these specifics, options, and procedures. The other question is about OC-managed buildings. Indeed, during the public consultation exercise, we received huge concerns from members of the public that for certain housing estates, many housing units are involved. They very much want the government not to put them under the future licensing regime. In fact, the management quality of these OC-managed estates is very high, and sometimes the number of housing units involved may not be huge. I still have 4 members for the first round: Mr. Christopher Chung, Chung Kwok-chi, Kwok Wai-chun, and Ms. Alice Mack. So next, Mr. Christopher Chung. I'd like to repeat our colleagues' views. I think it's better to have an exemption. Say if a member of the profession has been in the profession for decades, is very familiar with the residents of a particular building, but if such a person cannot obtain the qualifications required, it's not good, because educational qualifications do not guarantee good services. Secondly, I agree with Mr. Chan Paul. There are actual examples. I also have experience in this. In 1983, I bought this unit in a China Camp building. I won't mention management. I lived there for 4 years. In the 1980s, I paid $1,000 odd, over half of my monthly salary, before I could escape. It's because the developer commissioned its own management companies and cleansing companies. In a month, we could replace 180 neon lights. China Chem was a big company back then. It was the situation then. And then the tenants and owners said that they had to pay the ransom for Mr. Wang Dafei. But now many housing estates are managed by the property company as well, like Swire. Of course, if they perform well, it doesn't matter. Otherwise, it would be very undesirable. They just put their chop on documents. Even for HOS, many management companies commissioned by the buildings themselves had problems, and in certain cases even the ICAC was called in. Yes, standalone buildings may experience more problems, but even large housing estates may experience problems. Mr. Chan, may I repeat that building management is the responsibility of the owners. In fact, the management quality of OC managed buildings is not bad. In future, after the enactment of the bill, we'll have a licensing regime to regulate the property management services companies to safeguard quality. What about those members of the industry who've rich experience? Have you considered exemption? During consultation, we considered that for total exemption, that is grandfathering, that may not be the most proper approach, because our objective is to enhance the quality of the profession. We would like members of the profession to obtain qualifications, so we'll give them 3 years to obtain the qualifications required through continuing education. So we believe that we've already made sufficient arrangements. Next, Mr. Chan Kwok-chi. Thank you, Mr. Chairman. The paper mentions that there are 5,903 new buildings. The papers also say that these 3 new buildings may be exempted. But the information in the papers does not tell us how the government will follow up on these 3 new buildings. Will total exemption be granted, or will the government assist certain organizations such that the profession and these buildings will be able to attain the required standard? If we do not know how to handle management issues of these 3 new buildings, that will be tantamount to leaving them alone until something happens before we help them. So I'd like to know whether or not the government has specific solutions for the management of 3 new buildings. Mr. Chan, how to enhance the management of 3 new buildings? Thank you, Mr. Chairman. Thank you, Mr. Chang. Now we have 3,903 new buildings. Now this bill is to regulate property management companies and members of the profession. Anybody providing property management services has to take out a license. Now these 5,903 new buildings, they don't have OCs or residence organizations. They don't have any management. So it's not a question of management. The reality is that there's no management service for these buildings. But that doesn't mean that we disregard them. Under the Home Affairs Bureau, we do have arrangements to help these 3 new buildings, which are not organized or managed. Many of the tenants are actually low-income people and elderly people. So in the past, we launched numerous measures to take care of these 3 new buildings. We have a professional services scheme to make use of government resources to commission professional property management companies to pay visits to each and every household of these 3 new buildings to help them organize owners, organizations, to help them apply for funds to repair their buildings. The first stage covered 1,200 buildings and had been completed. In the next phase, another 1,200 buildings will be covered. So altogether 2,400. And then we have building management ambassadors. Many owners do not actually live in these buildings. They don't understand the crisis resulting from dilapidation. But the tenants themselves are worried because they would be affected by fire, for example. So we would assist these owners by way of these liaison ambassadors. who will provide intelligence to us for follow-up by the Buildings Department and the Fire Services Department, with over 1,000 such ambassadors. And over 1,003 new buildings have such ambassadors. Apart from providing intelligence to us, they'll also notify the residents of these buildings what they should do in terms of fire safety and building safety.
We also heard recently that the Community Care Fund has allocated special funding for these buildings to do maintenance work. So the 3 new buildings will be a major focus of our work in the future. So I'm very pleased to hear about your detailed responses. I think we can know more about the situation today. You mentioned just then 1,200 buildings plus 1,200 buildings. Does it mean that there are an outstanding 3,500 buildings? And is it that there will be money, surplus money, used in the future to help those buildings? I think we do need to get the information given to us in writing. We need to know that there will be 3,000 more buildings to be helped. This bill is to help buildings be better managed. So, and if there are other buildings also in need of help, we need to find the right way. Next one is Hon Wai-chun. Thank you. On this bill, just then Mr. Chen said that they want to focus on the bigger picture. We all support the overall direction. I personally is a member of the Eastern District Council, and I receive a lot of views from owners, flat owners, or complaints from owners against property management companies. Of course, the bill can correct the situation now. And as for the details, whether we can ignore them, of course, we can't ignore the details. Once the bill is drafted, how much it can be of help in correcting the situation, I think that's something that people are concerned about. And we also find from the paper that when it comes to licensing, management companies would be required to tell the authority about its portfolio of properties, number of management practitioners, and so forth. But I think that we can ask for more details. We need to get more basic information because a lot of the owners' corporations want to see some sort of scoring charts that can help them make a decision on which management company to hire in the future. So if the future authority can provide this kind of sort of scores, information about scores of individual companies, then that could help owners choose the right company. And we've also found that a lot of the management companies, they will say that how many managers, senior officers they have, but who will actually do the hands-on work? Maybe a company has 10 managers, 10 senior officers, but ultimately, because so many people are bosses, then in the end, they may have 5 or 10 managers, but in the end, they haven't got enough people to run a large number of properties. So do you have a ceiling on the ratio of, for example, managers to the number of buildings he's responsible for and so forth? I think all these information can help owners corporations make a choice on which company they should go for. I've seen management companies which can't even send a staff to attend the owners corporation's annual meeting, even though these companies claim to be big. And lastly, as for the grandfathering arrangement for petitioners, of course, we want to enhance the overall quality, and is it reasonable for the petitioners to go for continuing education? But what about those who have been in the field for a long time and who can't finish the continuing education in 3 years? What should we do? Because that person may have worked in the same building for a long time. If the building can provide some sort of proof, can we allow for extension of the 3-year period? Because since that person, I've seen petitioners I know someone who only have a primary education and yet he actually can perform the role of a surveyor engineer for a building, even though he has very limited education, and the entire owners corporation of that building is very pleased with him. So it will be a loss to the corporation and owners if a person like that, an experienced person like that, has to leave the job. Yes, just then your point about the information to be provided, we are concerned about that, and we do hope that in the future, through the future authority, we can disseminate online or to the public through other channel as much information about companies as possible. As for the ratio of managers, shareholders to number of buildings and so forth, we in the future would require management companies to give us information on the type of building size, of buildings and number of flats in the buildings being managed by them. Companies will also be obliged to update their information once there are changes. So they need to tell us the latest changes in the shortest period of time so that the public can make reference to them and through them make the right choice. And as for whether there can be companies that actually are working on a part-time basis and not providing full services, I think for licensed companies in the future, they must carry out the work that they are supposed to do. Otherwise, that would be contrary to the code of practice. I believe in the future, the petitioners would not be, actually doing their work, actually on a part-time basis. I think for experienced petitioners, I'm sure there are ways to accommodate their lack of education if they can provide information to show that the authority that they have the right credentials, then we will allow them to continue their service. Next one. Let me quote. As Mr. Chen said, in follow-up to the question raised by Chen King-po, for example, for the single block buildings, I understand what you're saying, but if an estate has a large number of flats, so we need to impose some kind of monitoring. I know there aren't any problems yet with these large estates, but we don't know what will happen in the future. In many residential estates, for small owners, if they're unsatisfied with the management company, there's very little they can do to make a change. So you believe that the owners can actually sort out issues with management of the properties, but I don't think that could be the real situation. After the bill is passed, the situation may also change. Why now, at this stage, do we not think about effective management of large estates? Just then you talk about the qualifications of petitioners. You're saying that they don't have to be very well educated, that as long as they can show their ability, that's fine. But so the issue lies with the authority. We don't know about the formation of the authority. It seems that you are letting the authority to make a decision in the future on, for example, licensing fees or other matters. For example, the retention of petitioners who are not that well educated. So therefore, but we need to be aware that we don't want the authority to have all the discretionary power in its hand. As we mentioned before, petitioners have said it seems that the authority, of course, the CE can appoint members to the authority or appoint a petitioner or anyone from the industry to the authority, but we don't know yet who will sit on the board of the authority. Why don't you spell it out in the bill then, so that we know, we don't have to guess who will be on the authority? Even the licensing regime would not cause people to lose their jobs. But let me remind you that for petitioners who are very well experienced, it's possible that they may not lose the job if they don't have the license, but they may be demoted. Maybe they've worked for a building for many years. They may be at a managerial rank. But once the licensing regime is in place, if they can't provide any proof then the company involved may demote them to the grade of maybe security guard. So the working conditions will deteriorate. I do hope that the administration would consider about not just the livelihoods but the remunerations in the future for this type of practitioners. As for the management by owners corporations, I think we need to consider another point. That is why owners corporations want to manage a building themselves. An important reason is because they may actually shoulder a lesser financial burden or cost managing their own building, because they will only need to hire security guards and cleaners. If you get a property management company, the cost will be much higher. So if you force these buildings to hire a company, then that would mean increased financial burden on the owners, because there may just be a dozen or so flats in the building, but the private management company would charge as much as managing 100 flats. So that in that case would be unfair to the owners, because they have to pay more to get a company to run the building. So there could be 400,000 families affected, in a large estate which is now owned by the owners corporations versus being run by private property management companies. But the bill now put before you actually does not actually address that particular issue. We would, through Chapter 354 and also the Buildings Ordinance, to address that issue itself. The administration is indeed looking into a review and possible amendments to Chapter 354 to plug potential loopholes. As for the chances of demotion of existing practitioners, we do want to see anyone lose their jobs or have their working conditions made worse. We just want to enhance practitioners' professional standards. We do all want all practitioners to be able to get a license within the 3-year grace period. We're not worried that there will be a great loss of staff or practitioners. Okay, anyone who wants to ask questions in the first round? If not, then we'll now go into the second round. 2 members have asked to speak, Chen Kim-po and Yik Chi-ming. Mr. Chen Kim-po first. Thank you. I'd like the Deputy Director to be aware and be alert to what we've said. Personally, I do not object to the government giving exemptions to single block buildings, small buildings. But I was telling you, please don't repeat the point they've made already later on. I know you need to give exemption to buildings with just, say, 10 or 20 flats, but I'm talking about estates with more than 10 blocks or more than 500 flats. Normally, people would think that these type of estates would need to be managed by a management company.
By way of this bill, you would like to attract more people to manage their own buildings. So why do you not want them to engage PMCs? As Ms. Alice Mack said, in future, these buildings won't be regulated. Even if they have 10,000 buildings in an estate, they won't be regulated, but there'll be problems. In Hong Kong, many people had to sacrifice because of this. I'm an owner in a housing estate with 2,700 flats, and I'm a member of the owners committee. All these years, I've witnessed a great deal of problems. Many unscrupulous elements want to form OCs in order to master everything. Even a PMC will have to be controlled by an OC. So we're talking housing estates with many blocks and flats. Why are you giving them a leeway? It's totally unreasonable. Please don't mind my agitation because I was very much agonized. So I'd like you to analyze views received in the public consultation exercise. How many blocks are you talking about here? Not many housing estates that came cover more than 10 blocks. And then I'd like to have written information from you in relation to these so-called single blocks. Under the property management ordinance, we've been suffering a lot. If I'm not going to say anything, I'm in dereliction of duty. Why are members so concerned? Because the existing ordinance is very problematic. 5 minutes. Thank you, Mr. Chan. Let me first say something about the 8,500 OC managed buildings. We'll analyze them to look at the composition of the OCs, how many blocks are involved, how many flats are involved, etc. There may be difficulties to go through all the 8,500 blocks. Maybe we can do it by way of sampling. We understand that the property management ordinance won't be able to overcome all property management problems. We are adopting a three-pronged policy. Number one, through the bill, we would like to regulate PMCs and PMPs in order to enhance their quality. And then through the buildings ordinance, we would like to perfect the regulatory regime such that owners can have proper provisions to manage their buildings in a timely manner. And then we have different measures to assist owners, corporations, and occupiers to manage their buildings well. Mr. Chairman, I want him to answer my questions squarely. Can we first analyze these 8,500 buildings first, such that we know the prevailing scenario, and then we'll see whether we should adopt Mr. Chan's opinion by drawing a line. I really want the government to consider whether or not there should be a bottom line for exemption. As for statistics, I'd like to know your principle. Are you not going to have any bottom line for OC managed buildings, irrespective of the number of flats, blocks, etc. involved? You can give us the figures later. Next, Mr. Frankie Yik. Thank you, Chairman. I agree with Mr. Hon Paul. I'm dissatisfied with the answers from the Deputy Director. We're not asking you to adopt a broad brush approach. Mr. Hon Paul asked for figures. You shouldn't evade the issue. And then Mr. Chan, you said all along that you had conducted detailed consultation, but I don't think any of us here was involved in the advisory committee. And just now I telephoned certain organizations. They said they did raise the issue of exemption, and you said that that wouldn't be a problem because there had been discussions on that issue. Now, you're telling us that apart from studying for professional qualifications, there are other options. Would you please tell us those alternative options such that the practitioners would feel comfortable? They're asking for exemption because it would be very problematic if in future experienced practitioners are unable to take out a license. Now, we mentioned single buildings, large housing estates with clubs, restaurants, and all sorts of facilities and services. They are managed by PMCs, but the experience and academic qualifications required are very different. There are two issues here. For OC managed buildings, I repeated many times that we would go back and collect information and data to see whether there's room for improvement. I'll come back to you next time. As for exemption for property management practitioners, the PMPs, will provide them with a 3-year transitional period. Later, we can give you supplementary information on alternatives. That is, apart from studying for the qualifications, are there other alternatives for these practitioners to convince the future authority that they satisfy the requirements? Mr. Chairman, I hope that they can do this quickly. During the consultation period, many practitioners did not pay much attention to this bill. It's just like the minibus drivers. They're asked to receive pre-service training. But now they're saying that they don't have sufficient manpower because at the start of the consultation exercise, the industries and professions won't be too concerned. But later, they discover problems. So please let us know the alternatives in order to allay the worries of the practitioners. And for different housing estates with different facilities and so forth, would you consider another tier of licensing? Well, I think you're talking about the PMCs. Earlier in our deliberation, we discovered pros and cons for a single tier and a 2-tier system. Eventually, we would like to have just one licensing regime. Why? Because many small and medium PMCs are worried that if they have different tiers, the small and medium PMCs won't be able to get a license for an upper tier. That may affect their reputation and image, and their business may be affected. Of course, if you get Tier 1 and Tier 2, the OCs will get Tier 1. Sorry, Mr. Chairman, I don't quite agree with him. I don't know why he has come up with this conclusion. You have to look at market demands. For properties with not many facilities, I have more room for survival. But with this broad brush approach, I may not be able to survive. Well, maybe I'm now on Tier 3. I can enhance the quality of my staff members so that in future I may go up to Tier 1 or Tier 2. But now, with a single system, you may be ousting the small companies. During the consultation exercise, we had representatives from big and small PMCs. The big PMCs could accept a single-tier system. As for OC-managed properties, in future on our website, details will be set out. Some PMCs have experience in managing big estates, some small estates. So members of the public can choose the most appropriate PMC through our website. Small buildings can choose small PMCs. Well, even government engineering projects have a tiered system for contractors. Mr. Paul TSE, sorry, I participated in this Bills Committee late. So if I asked questions that had been asked before, do bear with me. Now, for single buildings or blocks in a housing estate, if they're managed by the OC, well, of course, I understand that frontline practitioners don't need to take out a license. But what about shift arrangements, guiding principles, and so forth? What do you mean by a property manager? Is there a middleman? Is it that the OCs or owners organizations can immediately collaborate with a PMC? At the end of the day, a PMC will have to give guidance and guidelines to frontliners. You say without engaging a PMP. What if a PMP is not receiving salary or is not working full-time? Under what circumstances will he be considered as being engaged in property management? Mr. Chairman, under the proposed regulatory regime or licensing regime, we're talking about management through provision of services. If a PMC provides PM services, it has to take out a license. And for the PMPs in a managerial post, they also have to take out a license. For OC managed buildings, they don't need to take out a license. People engaged or commissioned or employed by them don't need to take out a license because there's no intermediary. So a license is not required for OC managed properties. People employed by them don't need to take out a license. But then, if a PMC provides PM services, a license has to be taken out. If a PMC only manages internal finance, internal personnel matters, then the managerial personnel do not need a license. Well, I don't understand. Well, if an OC does not employ a PMC, it manages its own building, then what's the definition of a PMP? Well, he is in a supervisory or managerial post. That's what you say. He has to be employed and work full-time before he can take up this managerial and supervisory role. If an enthusiastic member of an OC is responsible for making shift arrangements, inspection, and so forth, will he be considered a PMP? Well, the simple answer is no. So long as he is not employed by a PMC, even if he fulfills all the duties of a PMP, he is not considered a PMP. Well, Mr. Chairman, as I said just now, for an OC managed building, no PMC is commissioned, so no license is required for any personnel. Well, a PMC and its employees will have to take out a license, right, but not OCs, right. But what about in-house personnel? You mean the OC directly employs the personnel? Say, if one of the OC members conduct in-house duties, no license is required. That's a big loophole. Well, just now, members were discussing this. Now, the law is regulating good persons, but there are bound to be bad guys. So, Mr. Chan, would you please go back and consider this? Yes, Mr. Chairman, I have received this very strong signal from members. I will go back and study OC managed buildings. Any more comments? Ms. Claudia Mo, 5 minutes. Questions and answers.
I will need 5 minutes. Thank you, Mr. Chairman, for pointing out the loophole. Many owners corporations now actually have been complained by small owners as being just these owners corporations just looking after their own interests. And every time there's an election, the same people got elected into the owners corporations. So if there are, so there could be buildings which hire their own members or own friends to run a building. And if this situation persists, then that would be a big loophole. You said you would look into this again. How are you going to tackle this? Do you have any idea in mind? Why don't you just put these buildings under the licensing regime? I think we did discuss it, whether owners corporations running their own buildings should be subject to the regime. Basically, quite a number of buildings now are well managed by their own owners corporations. and the buildings involved can save management costs because they can hire their own cleaners and security guards. If we force these buildings to hire or to get private property management companies to do the management, then that may not be what those owners want. But I've heard the strong views and desire from members for us to review this exemption. We will look at the situation carefully and see whether there's any changes that can be made or amendments to be made. Obviously, of course, saving management costs seems to be an advantage. But if you just allow the situation to continue for the sake of saving money, then actually you need to think that our ultimate goal is to enhance management standards. So if there's such a big loophole, and you shouldn't just let people get their own gang members or friends to run a building just for the sake of saving money. We can't let people just run a building the way they like for their own interests. I think you do need to carefully consider plugging the loophole. Deputy Director, as I said, we adopt a three-pronged approach in building management. We also want to rely on Chapter 3-4 of the Buildings Ordinance to regulate owners' corporations, and we also have a series of measures for owners and owners' corporations to improve management of the buildings. So we are really taking a three-pronged approach. I think that would be an effective approach. Second round of questioning. Paul Chair has asked to speak. Do we need to clarify our legislative intent? Is our intention mainly to give owners choices and save money, or what? As we said, I think depending on your goals, some owners could be entitled to exemptions, or some buildings could be exempted. But if your goal is to give owners more choices, then there wouldn't be any need for a licensing regime. Now owners have all sorts of choices where to manage the buildings themselves or find a licensed or unlicensed companies. So we need to clarify our ultimate goal first. Otherwise, our legislative intent may not match what's contained in the bill. So I'd like to hear more because I missed your earlier meeting. Can you briefly tell us, Deputy Director? Yes, the licensing regime it has the ultimate goal or the only goal of enhancing the quality of building management as well as the quality and the standards of the practitioners involved. We did carry out widespread consultation when we launched the scheme. In Hong Kong, there are more than 8,000 buildings that are run by their own owners' corporations or organizations, and I've get strong views from these groups that they think that they have managed their buildings well, and they don't want to be subject to the licensing regime, with the result of actually causing disruptions to the existing management style. Management fees is only one of the considerations. The licensing regime proposed is trying to, or is intended to, strike a balance. I know you don't want to go too far in one go, but as you said, I understand the rationale for single block buildings, but if you still give estates with several buildings or blocks a choice of how to manage the buildings, I think that seems to run contrary to your original intention. Deputy Director, I think that's exactly what Mr. Chen Kin, Paul, and Frankie Yik said. We will collect more information, do more research on the 8,000 odd private buildings, and see the way to go from now on. I think members are pretty concerned about plugging the loophole. Yes, I think if your legislative intent is to regulate and put the management industry on the right track, then I understand why there's this bill. But if you are targeting at management of all the buildings in Hong Kong, then the bill seems to that doesn't really match the goal. Is it that you want to put the management industry on the right track, or to ensure that all buildings are in compliance with safety or other standards? Then I think you need to clarify further what you exactly want to achieve first. Our policy goal is very clear, to enhance property management as well as to enhance the quality of management companies and practitioners. Okay, third round. Frankie Yik. 5 minutes. 2 points. Once again, I want to emphasize that for any bill to come into effect, in order to enhance standards, you should be aware that this introduction of a new bill should affect existing practitioners. So, Deputy Director, I want you to really consider carefully any options that can put the minds of existing practitioners at ease. People have told me that if I had, studied well, if I, were able to get a good education, I would have gone to work for HSBC instead of joining the sector. And you haven't answered me a question as well as for your investigation into the, some trivial or disputes concerning building management. In the future, if there are complaints against building management, would you consult the buildings or estate, the owners corporations of buildings or estates concerned before taking action against the complaints, or upon getting the complaints? I received a lot of complaints against particular individuals or management companies. How would you handle complaints in the future? Deputy Director. Thank you, Mr. Yik, for your question. During the consultation period, we did thoroughly investigate this matter. We need to ensure that there will be a proper complaint mechanism so that owners and residents or users can make complaints to the future authority about management companies or practitioners. That's very important. We need to make sure that there is a fair, just, and open system. On the other hand, we need to ensure that we need to be aware of people making complaints with malicious intent. During the consultation period, we discussed various options or channels. Actually, we have an idea about the structure of the future authorities. There will be members responsible for handling complaints to make sure that we can strike a balance. That is, we can have an open system for people to make complaints, and also to avoid malicious complaints, trivial complaints that actually amount to nuisance to the people concerned. So we do have an idea in mind about how to tackle it. I don't know how you're going to handle it in the future, but with my past experience in providing public transportation, there are some members of the public who are so persistent that who can make complaints against a particular transportation mode every day. They can keep coming to you and making the same complaint every day, and you can see how reliable or valid these complaints can be. You need to respond to every complaint as well, and this, responding to them could actually put a lot of work pressure on the future authority or on a company. Well, I sit on all the meetings, and I attend all the meetings held by the Consultative Committee. If there are some meaningless or repetitive malicious complaints in the future, we will have a mechanism under which the authority can verify or can vet complaints and then do nothing about it if it turns out that the complaints are invalid. Okay, personally, I want to make 2 points. Firstly, about the one-tier system for licensing of companies in the future. I hope that whether you're using one-tier system or not, in the future you need to consider for the ratio of qualified staff. We mentioned that there may be companies that actually look after all sorts of buildings. For a property management company, various companies actually handle different types of buildings. So for different companies, maybe you should have different qualification requirements for their staff depending on the type of management that these staff do. As for the issue of exemptions, the number of properties being managed in terms of number of blocks, sizes, or flats, there isn't any ceiling now for a company. Members have also said that this could be a kind of detail that we need to look at. Deputy Director said that there could be some subsidiary legislations in the future. And we are concerned that subsidiary legislations could affect members' support for the main bill. I think we need to go into detail and focus on any issues related to the detail in the future. But I'd like to ask the administration to study, for example, issues like the 7 types of services provided, and our definition of types of services and so forth. So people might worry whether, if I provide this type of service, do I need to get a license for that? So the main bill need to clarify, the type of services for which licenses are required. So I'll ask the administration to really look into detail all these outstanding issues. Deputy Director, on members' concerns and questions, do you want to make any more supplements? Yes, just then. I think the chairman has made a very good suggestion. We will follow up on your points raised. And as I said, it's not that we only have the main bill. There will be details attached to it, and they are the details that had been thoroughly discussed during the consultation period. But we don't want to confuse you now with the details at this stage, at this early stage. So I just want members to focus on the main bill at the moment. But if during the clause-by-clause scrutiny period, if members want to get information about the details, if you want to have an idea of our subsidiary legislation to be proposed future, we do have an idea in mind. So when it comes to the scrutiny stage, we'll be very happy to submit to members our details, the details that we have in mind to be included in the subsidiary legislation. We can let you know in due course. So I may also ask the administration to give us some answers to questions raised today. So please provide us with the answers in writing, including, for example, how are you going to handle the situation of buildings and the kinds of buildings that are managed by owners themselves, and also the qualifications, requirements, or for experienced practitioners, possible exemptions given to practitioners experienced or very experienced.
Can they complete the training course within the time frame? What if they sit for examinations and cannot pass them, etc., etc.? Mr. Frankie Yik, Mr. Chairman, I'd like the Bureau to seriously consider what I said just now. I said just now that in the initial stage of the consultation exercise, members of the profession did not pay much attention to the exercise, and now they're coming forth to ask for this and that. Well, I think the definition of buildings and property management has a very broad definition. Some are single buildings, some buildings have a lot of facilities, clubhouses, etc. and the management of a swimming pool requires a great deal of knowledge and experience. Now, if my building is simple, I can engage a Tier 3 PMC. So that's good to have a tiered system. With a single-tier system, I may have to pay more. So that's how I view the issue. To put it in simple terms, there are different demands in the market. Even for construction contracts under the government, different licenses are required. I think you have heard them. Besides, I'd like to inform members that for the papers passed to you, we also have the submission from the Law Society of Hong Kong and the administration's response. That paper is about issues related to the provisions in the bill. So we'll take them up in due course. Besides, in May, on the 21st of May, our legal advisor wrote to the administration to seek clarification from the administration in relation to drafting. The administration sent us 2 reply letters in that regard. After discussing the policy areas involved, we'll proceed to the detailed provisions of the bill. If members have no further questions, we can adjourn the meeting here. Our next meeting will be held on the 4th of November, a Tuesday. I hope that the administration can give us written information and responses as soon as possible in relation to concerns raised today. Next time, if we can quickly resolve policy issues, we can proceed to clause-by-clause scrutiny of the bill. So, if there's no objection, if there's no other business, I declare the meeting adjourned. Thank you very much.